Hey there, students and teachers. Welcome to our session here. We are going to we're going to give an example of how to tackle the AP Government argument essay for 2020. Now, everything I've got for those of you watching on YouTube, everything is in the description. So you should be able to find everything. And actually, let me run in and put one more thing into the description. We'll go ahead and make a link to the Google Doc. Okay, so make sure that everybody has a link to the Google Doc that we're using here. Those of you in Crowdcast already have the relevant links. So as far as that goes, and if you want to be in my live sessions, make sure to go to crowdcast.io/Tom Richey, and you'll be able to be in future live sessions where I'm taking most of my questions. Okay, so with that, ladies and gentlemen, just a quick look, just a quick refresher on the 2020 AP Government Argument Essay Rubric. Okay, that can be found at my website. There is a link in the description. Okay, so looking at the Argument Essay Rubric, first of all, this is very dependent on a thesis. 7 points total. Only 2 of those points can be awarded without a thesis. Okay, so make sure that you've got a clear thesis statement and that the documents that you're using or the evidence that you're using clearly supports that thesis. So we see here where then after the point for the thesis, we've got up to 2 points that can be earned by using any 2 pieces of relevant evidence, like demonstrating that you've got any knowledge of AP US government that is relevant to this. And if you can do that, then you are good. Okay, so as far as that, you're going to be good if you can do that. Let me make sure I've got all excess tabs closed and all of that good stuff. All right, make sure for clarity in the broadcast. So from there, those can come from anywhere. Now, then we've got something here. Now, if there's no thesis, we can't go on from that. Okay, so relevant evidence, 2 of the 7 points, everything else is somehow tied to the thesis. Now, as long as you've got a thesis, then you can get an additional point if one of the 2 pieces supports a thesis. Now, this first point here in this section, it does not have to come from one of the foundational documents in the prompt. But to score the second point, you will have to use at least one of these documents that you use, or documents, court cases, anything else that you know from AP government. Okay, so anything that is out there, you're not confined to foundational documents. Now, the 3 documents, sorry, they're doing the yard work out there, so hopefully that's not getting too much into the audio. And so as far as that, in order to get this point, it has to be one of the 3 foundational documents that we're going to, that you're going to use here. And then finally, the last 2, not just that the reader sees that there's a connection between your evidence and the thesis, but you are actually explaining the connection. So that's what we're looking at here. So basically, 2 pieces of evidence, one of them coming from the documents. Now, because they use what they call positive scoring, they don't count off for anything that's wrong. They only give you credit for things that are right. If you want to use a 3rd piece of evidence, I don't have a problem with that. And so as far as that goes, as long as you can do it in the time limit, I don't see a problem with using 3 pieces of evidence. So there are a couple of reasons why I'm using 3 pieces of evidence in my essays, because first of all, I want to show you how that's a viable strategy. Second of all, I want you to be in a position where I want you to think about in terms of, if I'm using extra evidence, I'm giving you more examples. Okay, so it's not that you have to have more than 2 pieces. You're not expected to have more than 2 pieces, but I want to make sure that you are able to, see some examples of how we use this evidence argumentatively. Okay, so with that, let's go ahead and go into the prompt here. Okay, so I'm going to go ahead and pull up my file there. Let's see. So let me go ahead and get into here. I've got to get into my AP government folder real quick. All right, let's see here. So we're going to go into the pre-response. All right, argument essay. And so let's go ahead and open this up. I'm going to share my screen here again. And I've got at least one teacher in the audience, so it's going to be good to see if there are some other perspectives about some things that are going to be useful here. Okay, so with that, let's see, we've got this going on here. And this argument essay, remember, it always gives you an argumentative prompt that could be argued from either side. So remember, there's not a right or a wrong way to argue. All you're doing here is you are using at least one of these pieces of evidence plus a piece of additional evidence in order to make an argument. So what we see here, originally, the Bill of Rights applied only to the federal government and not to the states. In the 20th century, the Supreme Court has used the doctrine of selective incorporation to apply most of the provisions of the Bill of Rights to the states. Develop an argument about whether the selective incorporation of the Bill of Rights by the Supreme Court has been beneficial or harmful to the development of the United States as a democracy. Use at least one piece of evidence from one of the following foundational documents: Federalist number 78, Brutus number 1, or the letter from Birmingham jail. Now, this can be, remember, one of these can be your evidence. You can use two of these as your evidence if you want to. Nothing's stopping you from using both, using two of the three, or all three if you wanted to. But typically, you're going to be able to find something else. And remember that court cases become very relevant here because you can use a court case as your second piece of evidence. There are other concepts you can use as well. I would recommend using either a foundational document or a court case as your additional evidence. Now, if you're watching this later on, you may want to pause and try on your own, and then you can see what I did. Okay, so I'm going to demo this for you, but you may want to try it on your own. Just pause it, try it on your own, and come back. So if you want to do that now, go ahead and press pause, but I'm going to keep going. Okay, so with that, what we've got to think about is we've got two concepts here. Okay, we've got selective incorporation and we have democracy. Okay, so what we're going to think about here is how do we define our terms? Okay, so we've got the application of the Bill of Rights to apply to the states. And then we see here democracy. It could be majority rule and or equality. Okay, so if you think of democracy from an equality standpoint, you could use that. Just be careful about how you define democracy. That's really up to you. Democracy is somewhat of a nebulous term. And then you've got to give some thought for just a second about, okay, what would be the easier argument to make? Now, I'm going to make both arguments to illustrate to you what we can do here. I'm going to use some of the same evidence to make both arguments to show you how evidence is really portable between the arguments. So what I'm seeing here is on the pro side, I could say selective incorporation has been beneficial to the development of the United States as a democracy. Okay, because it has increased, it has supplemented majority rule, right? So it has created more equality and, has instituted majority rule or something like that. Okay, now I'm not really going to get into the thesis making yet. I've got some theses as I scroll down. Okay, but when we're thinking about this, it has been beneficial to the development of the United States as a democracy. Now, Federalist number 78, least dangerous. The judiciary is going to be the least dangerous branch to the liberties of the American people under the Constitution. You could argue that the Supreme Court really typically doesn't take rights away, that they are recognizing rights. You could use something like Gideon versus Wainwright. If you think about Gideon having access to an attorney. So let's think about something like that. Gideon versus Wainwright could be something here that you see where people got, the right to an attorney in state cases for people who cannot afford one. Okay, so when we think about this, the right to an attorney in state cases for people who cannot afford one, that this increases equality. Okay, so Gideon has the same ability to defend himself, to get legal advice, as someone who can afford it. You could define democracy in those terms. So remember that you're a little bit flexible about how you define it. Now, note here that Martin Luther King was in jail for violating a local law while exercising his constitutional rights. And so if we're thinking about that the Supreme Court, in making sure that people's rights are honored everywhere, regardless of where they live, we could use the letter from Birmingham jail for that. Now, notice that McDonald versus Chicago, I've got in both of these. One thing that I advise people to do is get a couple of court cases that you know really, really well. And you know them so well that you can use them for just about any prompt. Okay, I find that McDonald versus Chicago is very, very flexible in the way that it can be used, because on one hand, you could say, excuse me, you could say that the Supreme Court is not letting a local majority take away someone's rights because of where they live. Okay, so just because someone lives in Chicago doesn't mean that they would be denied their Second Amendment rights. Now, we could also say that selective incorporation keeps local majorities from fashioning laws that meet the needs of their community. Our argument here would be based on federalism. Okay, so selective incorporation has given a small group of judges the ability to influence policy regardless of how the majority feels about it. So when we look at Federalist number 78, maybe rights are upheld, but in a way that is undemocratic. We could go into how that is where also, when you think about Hamilton is defending an independent judiciary. Okay, so when Hamilton is defending an independent judiciary, he is defending a judiciary that is not accountable to the people. And so judges aren't elected. We could go into the unelected nature of that position. Brutus number 1, Brutus predicted that the federal court system would swallow up the state courts and the powers of the states. Basically, Brutus saw selective incorporation. When you read Brutus number 1, he saw this sort of thing coming, that the Supreme Court would tell people in states and local communities what they had to do and how they had to live. And so Brutus is someone that is kind of sounding a warning that the Supreme Court is going to become too powerful. And then we could see here that in a letter from Birmingham jail, the courts sometimes decide on what is right, because Martin Luther King's talking about what is right versus what is in the law. That there is there's really a higher law, that in the pursuit of justice, you can defy the law as long as you do so non-violently in a spirit of civil disobedience, is what he's saying in the letter from Birmingham jail. Remember that the Declaration of Independence and the letter from Birmingham jail are our two foundational documents that are not either a law code or a commentary on a law code. And so these documents are a little bit different. So as far as that goes, a few things that we can do here. Now, remember that because we only have free response, the 15 cases are really out the window. There's nothing stopping you from using another court case. Okay, so here's the thing, like when you look at Texas versus Johnson, for example, that was a ruling in the 1980s, a 5-4 ruling, where the Supreme Court protected flag burning. It was supported by only 20% of Americans. Engel versus Vitale, that is one of our 15. So you should know this one. Engel versus Vitale, this is a case where 70% of Americans opposed the decision which outlawed school-sponsored prayer as a violation of the Establishment Clause. Here is something that I found from the New York Times. You can see here public approval of major court decisions. And so what you can see here is there are some cases where you can see, okay, there are are, the majority is with the court. But if you look here, in a lot of these cases, the majority is not with the court. So when you think about, for example, school prayer, okay, so when you see a few decisions here on school prayer, Engel versus Vitale, and then in 2000, Santa Fe Independent School District versus Doe, where the Supreme Court said that public schools cannot sponsor a prayer before a high school football game. You can see that when it comes to the Supreme Court stance on public prayer, this is not democratic. Now, you could argue that it is Republican, small r, that it goes along with the idea of a Republican form of government, and it is protecting people's rights, if such a right exists, to freedom from religion. Now, that's where we get argumentative about this, because does the Constitution have a right in there, in our Ninth Amendment rights or in the First Amendment Establishment Clause? Is freedom from religion a right? And you can see here that I don't think that the majority of Americans, of course, we might need to update these numbers for 2020, but certainly at the time these decisions were made, the Supreme Court was going against the majority. So as I noted here, Texas versus Johnson, the flag burning case, only 20% of Americans agreed with that. Now, another thing here, when you look at Citizens United, okay, so the Citizens United decision, 2010, was only supported by 17% of the American public. And, I think I've given my view on this before. Just personally, I think that it goes along with the First Amendment and the Constitution. But at the same time, we can see that when it comes time to, when you start thinking about, do we want people being able to spend an unlimited amount of money in political campaigns? I can even say that I'm uncomfortable with that, even though I can understand the First Amendment basis for the decision. I can say, in terms of whether I think that that's a good thing, whether it's a good thing that Americans spend just an exorbitant amount on political campaigning compared to other countries. It's something, the Citizens United decision definitely was not democratic, because the Supreme Court is looking at the Supreme Court is inherently undemocratic, as we can see in Federalist 78, that it is independent from politics. And so that's something that needs to be thought about. Now, another one that we might want to note here is you've got New York Times versus the United States, where only 43% of Americans agreed with that decision, where the Supreme Court said that the New York Times could publish the Pentagon Papers. So you see that that was not a decision that was in line with majority rule. Now, another thing I wanted to note here is that Engel versus Vitale is misrepresented here. It says children may not be required to read a prayer in school, okay? Whereas Engel versus Vitale, they weren't required to read a prayer. Students did not have to participate in what was going on, but they did have to, they were in the school, so they would have heard the prayer said, but they didn't have to actually read a prayer in school. But you see there where we've got several things here. You see where the Supreme Court said that detainees at Guantanamo Bay can challenge their detentions in the U.S. civilian court system. Only about a third of Americans agreed with that. So when you're looking at this, we see all kinds of examples where the Supreme Court has made decisions, and those decisions have not been, in line with majority rule. Okay, so James says in the chat, USB coronavirus. And hello, Thomas. Yeah, James, I think I did see your email. Just follow up with me after the exam if you don't hear from me before that. Okay, so with that, let's go ahead and get into, so we've gone through a lot of evidence. So again, think about a few court cases that you might use. And remember, now that we're not, and Raul, if you want to chime in on that, we do have our 15 cases, but I think now if there's a case that's not in the 15 that a student wants to use and thinks, hey, I know this case, like this is something that wasn't in the 15, but I just happen to know about it, then you can use that too. I mean, really any relevant evidence is going to work. Now, if you're, I'd recommend definitely looking at the 15 because that's important and you've learned about those in class. But remember that anything that is relevant can be used. So, and with that, we've also got some study guides that we've put out through Marco Learning. If you'll visit Marco Learning's YouTube channel, I'll be doing a broadcast Saturday evenings at 9 p.m. the next 2 Saturdays at 9 p.m. Eastern. So let's go ahead and let's get into, yeah, I think that that what we've got here. So, we've got in terms of this that we can use really anything. Now, just to clarify, I mean, I have, I've asked around, and it does seem like the second piece of evidence does not have to be a foundational document. So let's note that, like when we're looking at the prompt here, that the second piece of evidence. So when we look here, one piece of evidence must come from one of the foundational documents listed above. A second piece of evidence can come from any other foundational document not used as your first piece of evidence, or it may come from your knowledge of court concepts. Now, I've added something here. Note, this can include Supreme Court cases, okay? So just make sure for the second piece of evidence. Now, one of them has to be from here, okay? But the second one, you've really got complete freedom here. And remember, we don't have to respond to an opposing or alternative viewpoint here. Okay, so with that, let's go into, what we're seeing here, that all kinds of things. Now, another thing that I noted here is Federalist 51. You could say that selective incorporation has thrown off this very delicate balance in Federalist 51. Note that Madison in Federalist 51 is not only writing about the checks and balances between the 3 branches at the federal level, but also the states. Okay, so he's also noting how the states could check the power of the federal government. Okay, so going from there, we can get into these essays. Okay, so I've got a pro essay and a con essay. Now, again, I'm showing you more than is necessary because I'm wanting to demonstrate how we can use evidence. So I don't want to just give you 2. I want to show you how we can put stuff in there. Now, you may not have time for 4, but I think you'd have time for 3. And remember the idea of positive scoring. If you use 3 pieces of evidence, then you are padding your score a little bit, just in case you might have misunderstood one of those pieces of evidence. So if there's a way that you can throw in a 3rd piece of evidence in a way that just flows naturally, I don't see anything wrong with that. So what we're going to say here, we've got our thesis statement. So we're going to have a thesis. Okay. Oh gosh, this mouse I've got is so sensitive. Okay. So we state our thesis. We have one body paragraph that's on one prong of the thesis, another body paragraph on the other, and then we restate our thesis without looking at the original, okay? Because maybe they didn't buy it the first time. Maybe we understand what we've said a little better once we've said it. So selective incorporation has been beneficial to the development of American democracy because it has increased the freedoms of Americans under the Constitution and has also kept the local factions from restricting constitutional rights. Now, you can tell here that I am going to be getting into Federalist 10 because I've used the word factions. I'm talking about the influence of local factions. Now, because of selective incorporation, Americans have more rights than they would have if rights were only protected by the states. Alexander Hamilton wrote in Federalist 98 that 78, they didn't go that far, 78, that the judiciary would be the least dangerous branch of government in terms of hurting Americans' liberties. And he has been correct because the Supreme Court has ruled in favor of freedoms that were not protected by states. In Brown v. Board, the Supreme Court overturned state segregation laws as a violation of the Equal Protection Clause of the 14th Amendment. Without selective incorporation, we might still see racial segregation in some states today because Congress had been unwilling to tackle the issue before Brown v. Board. It wasn't until after Brown that Congress started passing civil rights acts. The Supreme Court took the lead in promoting equality for all Americans. Okay, so with that, we're seeing how the Supreme Court is using, selective incorporation is typically, typically goes back to the 14th Amendment. Selective incorporation keeps local majorities. Now, note here that even if, if a reader wanted to be really stubborn and say, well, the 14th Amendment's not the Bill of Rights, I've made a reference to Federalist 78. Okay, so that's where, I'm kind of patting myself just in case a reader thinks that something's not in bounds. I don't see why Brown v. Board would not be in bounds here. But at the same time, I'm throwing in a little bit of extra evidence just in case the reader feels like I'm going out of bounds with one of those pieces of evidence or doesn't buy my explanation. Selective incorporation keeps local majorities from taking away constitutional rights that the majority of Americans support. Now, in this paragraph, I'll be doing exactly what Raul was talking about. I'm going to be using a court case along with a foundational document. So I'm going to be using Federalist 10 and McDonald versus Chicago as a supplement to Federalist 10. So in Federalist 10, Madison wrote that a large republic is beneficial because it keeps a single faction from controlling a government the way that is possible in a smaller republic like a state. Federal courts can apply the Constitution in a way that state courts cannot. In McDonald versus Chicago, the Supreme Court ruled that McDonald's Second Amendment right to bear arms had been violated by a local law that made it almost impossible for a resident of Chicago to legally own a handgun in self-defense. Even though the majority of Americans favor stricter gun control than we have now, the majority also supports the Second Amendment in general. And both of those can be backed up by poll numbers. You're not going to be expected to have poll numbers right in front of you or anything like that. Even if this is open book, open notes, you're not going to be expected to do that. But both of these are defensible claims that the majority of Americans want stricter gun control laws, but the majority of Americans also oppose just general bans on handguns and rifles or shotguns. So that's something you see, that the majority of Americans across the country support the Second Amendment in general, even if they want stricter gun control laws. In protecting McDonald's right to bear arms from being taken away by a local majority, selective incorporation helped to preserve a constitutional right for all Americans, regardless of where they live. Selective incorporation has been beneficial to the development of American democracy because it has led to the protection of equal rights and has kept local majorities from taking away the constitutional rights of Americans. Now, note here, I used more evidence than necessary. I brought in 4 pieces of evidence. I only needed 2. So with that, I just, if it can strengthen your argument, go ahead and put it in there. You know what you're talking about. It can strengthen your argument and you're not running out of time. This is something that I think a student that's heading toward a 4 or 5 could do in 25 minutes. Okay, just setting it up real quick and going with it. So that is the pro. I've also got a con argument. Let me see as far as what we've got here. Then yes, okay. So yeah, making sure you have a thesis and make sure students don't write themselves out of a point. Yeah, so as far as that goes, you want to make sure to stick with what you know about something. So for example, I think that what Raul's saying is, my point is we want to bring in maybe a third piece of evidence just in case one of the pieces of evidence doesn't work. But you could write yourself out of a point if you are in a situation where you were talking about Federalist 78 and you went into so much detail and then you said something that was like, okay. So that's something you want to make sure that you stay on what you know. Okay, you stay on what you know. And so as far as that goes, let's go ahead and go into the con. And note on the con, I'm going to use some of the same evidence that I used in the pro, okay? So here I'm going to use Brutus number 1, McDonald versus Chicago, Engel versus Vitale. So I'm going to note how selective incorporation can undermine democracy, looking at democracy as majority rule. Selective incorporation has been harmful to the development of American democracy because it has kept the people of the states from making laws that benefit them. and also resulted in some decisions that have undermined majority rule on a national level. Okay, so we're going to note here that I'm going to be looking at democracy only through the lens of majority rule, and I'm going to make one argument that says that the Supreme Court is not allowing people to make appropriate laws within their communities. And in the second paragraph, I'm going to go into how we see that the Supreme Court has undermined a national majority. Selective incorporation undermines the ability of states to make laws that are best for the citizens of that state and are popular within the state. In Brutus number 1, an anti-federalist argued that the creation of a federal judiciary would undermine the state courts and take away their dignity. Brutus believed that the Constitution would turn the United States from a federal republic into a single nation. And that is exactly what selective incorporation has done by giving the Supreme Court the power to overturn state and local laws. An example of this is McDonald versus Chicago, where the Supreme Court declared that the state and local governments have to allow residents to keep firearms in their homes, even if that goes against the wishes of the majority of the people in a state or a local community. Allowing someone to have a gun when the majority of the community doesn't want anyone to have a gun may be constitutional, but it is not democratic. In addition to, and we want to remember that, our form of government, we are a democratic republic. We are not our Constitution is not a constitution for a Republican democracy or a direct democracy. We are a democratic republic. So we see here that, when somebody asks, is the government of the United States democratic? It's like, well, kind of, but not really. And this is a clear example of that in terms of, when we think about the people of Chicago from that perspective. In addition to undermining the wishes of local majorities, selective incorporation has also allowed the Supreme Court to undermine the wishes of national majorities. One of the court's most controversial decisions was Engel versus Vitale, in which the majority of the court voted to overturn local school prayer, even when the students were not required to say the prayer, and the prayer said nothing about Jesus or the Christian religion. The Engel decision was only supported at the time by 30% of Americans. 9 people got to overrule 70% of the American population that supported public school prayer at the time. This could be part of the reason that the United States has grown less religious since the 1960s. The Supreme Court doesn't have a right to direct not only the present, but the future course of American culture. Okay, so I'm going to note there, I'm going to simplify a little bit. I'm going to simplify that sentence a little bit. Selective incorporation has not been helpful to the development of American democracy because it has undermined the ability of states to make laws that are appropriate for the majority of their citizens, and has resulted in the court making some decisions that have been unpopular with the vast majority of the American people. So again, we used something from this. We used Brutus number 1, and Brutus number 1 was supplemented by 2 Supreme Court cases. And you see here where when Raul was talking about, if you're going to use a court case, use it in conjunction, like use it to support that foundational document that you're using. So that's going to make your argument overall coherent. And so hopefully y'all found that helpful in terms of getting that set up. Now, remember, you can go, if you're watching on YouTube, we've got links in the description, and you also want to subscribe to Marco Learning's YouTube channel. That's youtube.com/Marco Learning, all one word, because I'm going to be doing broadcasts for AP Government on Saturdays at 9 p.m. Eastern. So with that, ladies and gentlemen, this has been a good class meeting, and I will be back with some more AP Government related broadcasts in addition to AP US History and AP European History. It is always a pleasure, ladies and gentlemen.